Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast, the NJ Laws Tube. In this edition, we look at speeding tickets and radar. It's well established that the prosecution of a defendant for a motor vehicle violation is a quasi-criminal proceeding. In such a proceeding, the burden of proof is upon the state to establish all elements of the offense beyond a reasonable doubt. In every charge of a speeding violation, the complaint or summons should specify 1. The speed at which the defendant is alleged to have driven, 2. The speed which is prima facie invalid, and 3. The time and place of the alleged violation. Let's say again. A sign showing a speed limit is merely notice of the law or an ordinance regulation prohibiting a greater speed. The sign itself does not set the speed limit. Now, speed measuring radar in various forms has been accepted since the New Jersey Supreme Court case of State versus D'Antonio. Now, it's not necessary for the trial court to make a particular finding as to the precise speed and excess of speed limit at the time of the violation, just that they exceeded the law. However, if the defendant is found guilty, beyond a reasonable doubt, the trial court should determine how many miles they were in excess over the speed limit to determine what the penalties are. Now, in New Jersey, the landmark case establishing how radar works was State versus Wojkowiak, spelled W-O-J-K-O-W-I-A-K, decided back in 1979. And there the court determined how the radar worked and found that the K-55 radar was scientifically reliable, and that you have standards for the operator being qualified and how the device should be properly operated. Recently, the courts have looked at the laser technology, and the appellate division affirmed a decision by Judge Stanton where he found that the laser was deemed to be reliable. Now, the municipal courts follow what's called a bench book, and they look at cases, and there was a case called State versus Van Syck where there was failed to object to the introduction of the radar evidence as excessive speed, and because there was no objection, the court found that since the radar speed went in, there should be no objection. Other methods for determining speed are called the pace, and the pace or clock method is performed by an officer in a patrol car with a calibrated speedometer and for a duration of distance where the officer can accelerate and then keep an equidistant same speed, and they basically look at their speedometer. The more common methods are either radar or the laser speed detection. And as I said, back in 1988, the court in the matter of the admissibility of motor speed regulations called the LTI Marksman speed detection device was found that it are generally accepted in the scientific community, and that they should be permitted as long as the operator of the laser is properly certified, and that the court ruled that expert testimony was not required, but that appropriate training of the officer operating the speed detector should be shown in each case, and pre-operational checking procedures recommended by the manufacturer should be shown to have been made in each case, and if there's more than 1,000 feet of distance, there would be a requirement of the speed machine needing expert testimony. For additional information on speeding law, go to website njlaws.com, that's njlaws.com, or benotguilty.com, that's benotguilty.com. If someone is traveling at an excessive rate of speed, let's say 30 miles over the limit, they should probably consult an experienced attorney. In Central Jersey, contact the law office of Kenneth Vercammen, 732-572-0500. Also at 1-800-NJ-LAWS-7, that's NJLAWS-7. Located at 2053 Woodbridge Avenue, Edison, New Jersey. Thank you, and good luck.